We're now live from The Hague at the International Court of Justice, as today the case brought by South Africa against Israel and the ongoing war in Gaza is being brought to be...
Notwithstanding the incontestably serious nature of the allegations against Israel, the court should not be required, before granting provisional measures, to ascertain whether the existence of a genocidal intent is the only plausible inference to be drawn from the material before it. That would amount to the court making a determination on the merits. Moreover, South Africa has stressed that any motive or effort by Israel to destroy Hamas does not preclude genocidal intent by Israel towards the whole or part of the Palestinian people in Gaza. Evidence of other motives explaining its conduct as a perpetrator will not save Israel from a finding that it also possessed the requisite genocidal intent. And because of a fundamental feature of genocide, namely that the prohibitions on genocide and associated offences are jus cogens in nature, they are subject, therefore, to no exceptional qualification. They are absolute in nature, in times of war and peace, always and everywhere. Furthermore, the fact that the alleged acts may also be characterized as crimes other than genocide should not exclude the plausible inference of the existence of genocidal intent. As the UN Secretary General has stated, the prevention of genocide is intrinsically connected to preventing crimes against humanity and war crimes, as these crimes tend to occur concurrently in the same situation rather than as isolated events. Consequently, he said, initiatives aimed at preventing one of the crimes will in most circumstances also cover the others. And as also set out in the ILC articles on state responsibility, the wrongful act of genocide is generally made up of a series of acts which are themselves internationally wrongful. Madam President, honourable members of the Court, South Africa's claims thus concern, in the first place, its own obligations as a state party to the Genocide Convention to act to prevent and punish genocide. In the application, South Africa has stressed that it is acutely aware of its own obligation as a state party to the Convention to prevent genocide. Indeed, this court has recognized the universal character both of the condemnation of genocide and of the cooperation required in order to liberate mankind from such an odious scourge. As the prohibition of genocide is assuredly a peremptory norm of international law, or jus cogens, it is crucial that states pursue their interest under the Convention in ensuring acts of genocide are prevented. Additionally, due to the special characteristics of the Genocide Convention, the respondent state owes this duty not only to the Palestinian people, but to all states parties to the Genocide Convention, including South Africa. This has been emphasized repeatedly by this court and most recently in the Gambia case, where the court held, and I quote, all the states parties to the Genocide Convention have a common interest to ensure that acts of genocide are prevented, and that if they occur, their authors do not enjoy impunity. That common interest, said the court, implies that the obligations in question are owed by any state party to all the other states parties to the Convention. Similarly, the court has reiterated that in such a convention, the contracting states do not have any interests of their own. They merely have, one and all, a common interest, namely the accomplishment of those high purposes which are the raison d'etre of the convention. Accordingly, any state party to the Genocide Convention, and not only a specially affected state, may invoke the responsibility of another state party with a view to ascertaining the alleged failure to comply with its obligations, erga omnes partes, and to bring that failure to an end. That means that South Africa is asserting both a collective and an individual right. It is thus beyond doubt that South Africa is entitled to invoke the responsibility of Israel under the Genocide Convention. Through South Africa's interest in the common interest, and as a state party to the Genocide Convention itself, it is entitled to safeguard compliance with that instrument. As has been explained, the events unfolding in Gaza at the hands of the Israeli forces are frighteningly unprecedented. Yet what this court is being asked to do in these proceedings, interdicting genocidal acts on an interim basis, is sadly by no means novel. In relation to genocide, the court has indicated provisional measures in analogous circumstances to these. In the Gambia case, where, as here, a state sought provisional measures on the basis of the erga omnes right that the Genocide Convention be complied with. Also in respect of genocide, the court did the same in the Bosnia and Ukraine cases. And most recently, this court further accepted the erga omnes character of parties' rights in relation to the Torture Convention. So South Africa respectfully contends that in this case, the rights of the Palestinians in Gaza are no less worthy of this court's considerable protective power under Article 41 to issue provisional measures. This court cannot but find, as it did in the Gambia case, where this court held that there is a correlation between the rights of members of groups protected under the Genocide Convention, the obligations incumbent on states parties thereto, and the right of any state party to seek compliance therewith by another state party. South Africa's request therefore complies with Article 41 of this court statute and engages the power of this court to preserve by such measures the rights which may subsequently be adjudged by it to belong to either party. South Africa requests this court to discharge that critical protective power, and South Africa does so by virtue of its own clear right and solemn obligations held towards the international community as a whole. For the court to indicate one or more provisional measures, there must also be a link between the rights, the protection of which is sought, and the provisional measure being requested. Such a link manifestly exists, we say, between the rights claimed by South Africa in its application and the provisional measures requested, which are directly linked to the rights which form the subject matter of the dispute. The provisional measures sought therefore ensure the protection of rights which might ultimately form the basis of a judgment in the exercise of the court's jurisdiction in due course. The rights at stake in these proceedings are certainly at least plausible, grounded in a possible interpretation of the Convention, and as the Convention imposes on parties the obligation to prevent and punish genocide under Article 1, and in doing so intends to protect groups and parts of groups from genocide. The Convention was designed to protect both states, parties, and human groups. When acts in breach of the Convention are perpetrated, it is the fundamental rights of people and the relevant group that are violated. Those fundamental rights of Palestinians in Gaza would be the subject of any judgment by this court on the merits. Madam President, members of the court, to find otherwise will not only be to treat Palestinians differently as less worthy of protection than others, it would also be for the court to unduly limit its own competence, to turn its back upon its extensive prior jurisprudence, and to close its eyes to the breach of the rights which lie at the heart of the Convention and which breaches are taking place in Gaza right now as I close. Madam President, I ask you now to call Ms. Negrali KC to the podium, who will address you on a risk of further genocidal acts, the risk of irreparable harm and urgency, and I thank you for your attention.
I thank Professor du Plessis, and I now invite Ms. Glini Negrali to take the floor. You have the floor, Madam.
We're live from The Hague, where we've just been listening to Professor Max du Plessis, who's representing South Africa in this historic case, as he described Israel as regarding itself as beyond and above the law. South African Justice Minister Ronald Lamola outlined the country's genocide case towards Israel earlier in the proceedings, where we also heard from Advocate Tembeka Kukaita Toby and Advocate Adila Hassim.